Hello, my name is Jacob Aronauer. I am the managing partner of the law offices of Jacob Aronauer. I am here to do a quick Zoom session with Karin, riding the coattails of Sian and Karin's very successful Zoom session last week, talking about my practice. And in fact, it got such good feedback, Karin, that we received fan mail asking questions, wage and hour questions. How about that, huh?
Awesome. Yeah, that's great.
Yeah, totally unexpected. A very nice surprise, but the people have spoken. So despite the pandemic, we're here, we're doing it. The first mail we got was Clint from New Rochelle. Clint from New Rochelle asks, I am an illegal immigrant, but I know that my employer has been unlawfully denying me overtime. What rights, if any, do I have? Clint, this is a very good question, and we get this a lot in our line of work. Karin, what would you tell Clint? Poor Clint.
Yeah. For the wage and hour cases that we do, which means people who are not paid minimum wage or overtime correctly, your immigration status is what we call not discoverable. That means that the other side can't ask for your immigration status. It doesn't come up in court. Because yeah, the case is not about your immigration status. It's about the fact that you weren't paid correctly. Yeah, Jacob, anything else to add?
Yes, I do have something to add, Karin. I would also note that consistent with not being able to ask about one's immigration status, tax information is also not discoverable for the same similar reasons. The courts want illegal immigrants to be able to bring claims because they don't want employers to take advantage of employees who are illegal immigrants and not pay them correctly. So tax information is also not discoverable. The courts have made that very clear in close to 10 years of private practice. I've never seen the court permit the employer to get that in discovery. So that's something to keep in mind. So Clint, if you think you have been paid correctly, you should contact an attorney ASAP, preferably someone who has experience in this area of the law, and pursue your claims vigorously. Okay. We got one more letter. Open it up. Okay, this question is from Rebecca, who lives in Staten Island. Rebecca says, I recently was terminated by my employer, who I've been working for almost 30 years. That's a long time. I'm sorry, Rebecca. Rebecca says, I'm a 55-year-old lesbian and I'm handicapped. Do I have a lawsuit? And, what we do, and I think Karin can attest to this, is that when somebody's terminated, Karin, if somebody just in general walked into our office and said, I was fired, do I have a case? What would you tell them? And then we'll get into Rebecca's situation.
I would say probably not. In New York, it's a right to work state, so your employer can fire you for whatever reason they want to. You can also leave for whatever reason you want to. The exception to that is that if you are a member of a protected class, then you can't be fired on the basis of being part of that class. So you can't be fired for your gender, you can't be fired for pregnancy, for sexual orientation, age, yeah, lots of different things in there. Want to add some, Jacob?
Oh, I think you hit most of them. What I do when a potential client walks into the office and they say they were terminated is I kind of do what Karin just did. I have a checklist. Do you think you were fired because of your age, your religion, sexual orientation, religion? Did you engage in any protected activity with respect to these? So, for example, did you tell your employer, I can't come into work because it's a religious holiday, and then you were fired the next day, or something of that nature? Did your boss find out that you were a lesbian, and then 2 days later you were terminated? So, those are questions I would ask. I mean, what often happens, unfortunately, is I say, okay, why were you fired? Oh, my boss is a jerk. My boss doesn't get me. I didn't get along with my boss. I would say in a situation like that, it's sort of tough cookies. But with respect to Rebecca, it would seem just from her letter that she would fall into three protected categories. The age, you can't fire somebody just because they're, for lack of a better word, old. The cutoff or the protected age begins at 40, so Rebecca's 15 years past that. At age 55, she's a lesbian, so that's also a protected sexual orientation. And then she's also disabled, although I don't know the extent of her disability. And just because, Rebecca has those three protected categories, that doesn't mean that the employer can't fire her. I think, Karin, we would then, kind of ask Rebecca, okay, well, did your boss know you were a lesbian or something like that? Would you agree?
Yeah. Yeah, and we would try and get an understanding of what her employment situation was like, to understand how like why she thinks that she was fired for being a member of those protected classes. Yeah, so that involves like lots of stories, really trying to get an understanding of what it was like for her to work there, understanding how she was treated differently from her coworkers to try and help establish a case. Yeah.
Right. So, I mean, like, to give an extreme example, let's say Rebecca was in the same position of 10 other people, and the 10 other people were all heterosexuals, and they were all paid $50,000 a year more than Rebecca. And Rebecca's work was just as good, or if not better, than those 10 other people. That would be something that Rebecca would then have probably a very strong case just from hearing that.
Yeah.
So Rebecca, I'm sorry to hear about your situation, and hopefully our firm can help you if you want to come in for a free consultation. So we only had 2 questions today. Both questions were great, and hopefully next week we'll have more fan mail and we'll be able to answer them for you.
Yeah, great. Talk to you later, Jacob.
Talk to you later, Karin.
Mhm.